He says it was assault. Why does he want to do the attempt or no too?
Mr. Townsen, are you ready with one of your clients?
I have Mr. Austin back here, Your Honor, on the motion to consolidate. My understanding is that's going to be made moot because Mr. Aaron Beck would intend to plead.
Okay, Mr. Mertz, did you want to go forward with that case?
Yes, please.
Okay, we'll call People versus Aaron Beck. This is case number 235265 and 5266. The record today. I could have counsel, but you're going to be so.
Here, on behalf of the people.
Depending on whether we're with you, if you would be concerned.
So Mr. Mertz, do we have a plea agreement in this case?
We do, Judge. The plea offer is an out of town of an attempted R&L 1-year misdemeanor. Mr. Beck intends to take advantage of that plea offer. I've reviewed his trial rights with him as well. And then that would make the motion to consolidate moot at that point. And then we did have a separate motion as well to suppress some of the evidence pursuant to the transcripts of the running of the exam. And that'll be moot as well. And that was set for April 5th.
So is that a correct statement of the offer?
It is, Your Honor.
Mr. Beck, have you had an opportunity to go through this plea agreement? About that?
Yeah, yes, Your Honor.
Is that how you want to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Mr. Beck, are you currently on any kind of probation or parole?
No.
And as Mr. Murthy said, the maximum penalty that you could face for this charge would be up to 1 year in jail. Do you understand that?
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
1 year.
How are you?
Guilty.
I know Mr. Murthy's gone through your rights with you. I'm going to go through them with you also here on the record. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you here at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all of those rights?
Yes, Your Honor.
Can you tell me what will happen to those rights by you pleading guilty?
1 year mission.
Yeah, but all those rights that we talked about, do you know what's going to happen to those rights based on your guilty plea?
They're gone.
Yes, that's right. Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here in court today?
No, Your Honor.
Your own free choice to enter this plea.
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
Okay, this happened back on September 2nd, 2023. Is that the correct date?
Yes.
On that day, did you come into contact with an officer from the Crawford? That officer wearing his uniform?
Yes, Your Honor.
Did you know that he was performing his duties as a police officer at that time?
Yes.
And did you in some way attempt to resist or fail to comply with an order that he gave you?
Yes, Your Honor.
Okay. Great. That happened here in Crawford County.
Yes.
And I think he's met all the elements.
I would agree, Judge.
Ms. Coke, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No.
Ms. Coke, are you satisfied that the court has complied with statute and protocol in the taking of this plea?
Yes, Your Honor.
I agree with you.
Mr. Beck, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of the attempted resisting and obstructing the court will accept your guilty plea. Do you want to set the sentencing on a separate date, Ms. Coke?
Probably yes, because I think his brother's going to plea as well today.
So, Mr. Haven, if we could just have a misdemeanor report prepared or Mr. McDowell.
We can do that, yeah.
So Mr. Beck, you're just going to meet with the probation agent before you leave the court. today, they're gonna set up, presents here for you, okay?
Okay, thank you, Your Honor.
Mr. Townsen, did you want to speak with your client?
Yes, Your Honor, thank you. Jason Thompson on behalf of defendant Austin Beck. Mr. Beck, just go ahead and stand at the podium. I believe there's a plea offer in this matter, Your Honor. Mr. Beck is being charged with 1 count of resisting arrest. Prosecutors indicate that's 2-year felony. Prosecutors indicated she would offer a attempted resisting arrest, that'd be a 1-year misdemeanor. For most purposes, attempted felony for purposes if there was a habitual offender felony situation in the future.
That is a correct statement of the offer, Your Honor.
Okay, and I apologize. I was trying to find this.
Oh, okay. I think it might be a 10-15, the actual pretrial.
Yeah. All right, so. I'm sorry, making you go through that again.
No,
Can you
no,
tell me
no.
the terms again, please?
So now that we're on the record again, Your Honor, the plea offer today would be that Mr. Beck stands accused of a 2-year felony resisting arrest. The prosecutor would offer the 1-year attempted resisting arrest. That's a misdemeanor for most purposes. It's attempted felony for purposes of if there's ever a habitual offender designation.
Okay, hope you indicated that as correct.
It is.
All right, Mr. Beck, have you had an adequate opportunity to speak with Mr. Thompson about this plea agreement?
Yes, sir.
Is that how you want to proceed today?
Yes, sir.
You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Mr. Beck, are you currently on any kind of probation or parole?
No, sir.
And as Mr. Thompson indicated, the maximum penalty you could face for this charge would be up to 1 year in jail. You understand that?
Yes, sir.
With that maximum penalty in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf if you're at trial. You have the right to remain silent during a trial, to not have that silence used against you. The right to testify at a trial yourself if you want to. You understand all those rights.
Yes, sir.
Giving up and waiving all of those rights, including the right to have a trial.
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here in court?
No.
Free choice to plead guilty.
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
This happened on September 2nd of 2023. Is that the correct date?
I believe so.
On that date, were you here in Crawford County?
Yes, sir.
While you were here in Crawford County, did you come into a contact with an officer from the Crawford County Sheriff's Department?
Yes, sir.
Was that officer wearing his uniform?
Yes.
Did you know that that officer was there performing his duties as a police officer?
Yes, sir.
Did you in some way attempt to resist that officer or fail to comply with orders that he was giving?
Yes, sir.
Satisfied?
Yes.
Thompson?
I don't recall if we asked if that occurred in Crawford County. I thought.
I did, yes.
Okay, no further comments.
Okay. So are the people aware of any threats, promises, or inducements other than what's been placed on the record?
Your Honor, I'm not sure of his status on any other cases that this may affect him, but we may want to let him know that if he has other cases going, he may have felonies on a deferred status, so I don't know if we need to address that.
You indicated you're not on probation?
No.
Okay,
I got hideout down in Livingston County. When I
Okay.
was a juvenile.
okay.
So can I inquire?
Yeah.
So Mr. Beck, is that case concluded?
Yes.
All right, you're no longer on probation.
No.
Okay, no further questions. Thank you.
Thank you.
Mr. Thompson, are you aware of any other threats, promises, or inducements?
No.
Ms. Koch, are you satisfied that the court has complied with statute?
Yes, Your Honor.
Mr. Thompson.
Yes, Your Honor, thank you.
Mr. Beck, the court finds that your plea is knowing, voluntary, and accurate. The court is under factual basis. The court of finding you are guilty of the act of resisting. The court will accept your plea to that charge. You're going to meet with the probation agent here before you leave to set up a pre-sentence interview, and then we'll set this for a sentencing hearing. Just make sure you stay.
Thank you.
Thank you.
You're gonna talk Mr. Haven now. Thank you, Your Honor.
Are we ready to proceed on that case?
Yes, Your Honor, thank you.
The court calls people versus Ryan Ramsey, case number 235221. Record to reflect Mr. Ramsey is present here in the courtroom today.
Miracle can be after the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant Brian Grigsby.
And in this case, we have, it's set for trial. We have offered the assault and battery. This was a late offer plea because the victim did not consent to that. And so I didn't make that offer until she consented. I met with the Army victim advocate. Well, we've talked to her throughout this case, but we had a sit-down meeting and met with the victim. We had a conversation, and she does consent to that offer now. Based on those conversations with the Army and the victim, this is a new offer, and we appreciate the court taking a late plea.
All right, can you state that offer again?
He will plead to assault and battery and dismiss the CSC fourth counts.
So just a misdemeanor assault there.
Yes.
Mr. Thompson, is that your understanding?
It is, Your Honor. Could I ask for just a minute to go over to my client in terms of the application?
Yes.
All right, thank you. Appreciate it.
You need, how much time do you need for that?
Approximately 5 minutes.
Okay. While we're waiting for that, let's take, Mr. Grigsby, we're going to go off the record for just a minute so that you can meet with your attorney here.
Yes, Your Honor.
Okay. The court calls people versus Frederick Mellon, case number 235262.
Miracle can be after the people.
Yeah.
Right.
Are you gonna go tell her?
Yeah. Oh, thank you. It's gonna send me a message.
Mr. Gerber, we're on the record in people versus Frederick Mellon. This is case number 235262. The set for hearing at 9:15 is now 9:30.
No, Judge, I haven't seen Mr. Mellon.
Contacts with him.
The last contact I had with Mr. Mellon, he indicated that I was not doing my job and he was gonna address things with court. He's not here, so I have no idea.
This was set for a show cause hearing today. Let's go for it. Go ahead and
No, Your Honor, I asked for that on 12/7, but there was some indication he may have medical issues, so the court issued a show cause, so I would ask for bench warrant.
Okay, so the court will sign that bench warrant. We'll proceed further with Mellon's case once it's arrested. And we'll take a short recess. We'll be back on the record in about 5 minutes.
says it's addressed to the clerk, but apparently it didn't actually go to the clerk.
Mr. Russell, are you able to hear me okay?
Yes, sir.
Okay, before we start your hearing, your lawyer has indicated he wants the chance to speak with you, so I'm gonna put you into a breakout room with him so that you can have a private discussion before we have your hearing, okay?
Thank you, sir.
And Mr. Gerberty, are you able to hear me?
Yes, sir.
Okay, I'm opening up the breakout room right now. Ms. Pope, I don't know if your advocate wants to get rid ahead, Ms. Cummings and the victim advocate from the National Guard.
Just show up. Yes, they're.
Well, no, I didn't. They were here. I let them into the hearing, but I didn't realize that I did not have our microphone turned on here, so
Okay,
they would not have been able to see or hear what happened.
all right.
So I think they let them know. I just realized that as I was looking at this next hearing.
Did you finally get a plea on Burr?
Yes.
To what?
54.
That's charged. You mean, it's a standard offer. It's like 19 grand from the cops. You never did that? I never did that. Come on. What are you doing? You're 19.
Pager.
You'd run into the woods and never got caught. You've been. That's the goal of the exercise.
Are we off YouTube?
Like I can make that too.
What?
Says live.
And the microphone, I think now. Yeah. Still live.
Mr. Russell, are you able to hear me okay?
Yes, sir.
Okay. Okay, we're on the record in People versus Russell. This is case number 235164. This was originally set for 9 a.m. this morning. There was a delay based on circumstances at Saginaw Jail. But we do have Mr. Russell available now. He previously waived his right to in-person sentencing, but he is present by Zoom video. The record should reflect he's had an opportunity to speak with counsel in a breakout room prior to the hearing this morning. If I could have both counsel for your appearances on the record.
Sierra Coke on behalf of the people.
Thank you, Honorable Ramsey, on behalf of Mr. Russell, and he's appearing by Zoom. He's previously indicated waived his right to be here in person, and I'm here in the courtroom in person.
Thank you, Mr. Russell. Have you had an adequate opportunity to go through the pre-sentence report and speak with Mr. Gurmurthy about that today?
Yes, sir.
And Mr. Gurmurthy, are there any additions, deletions, or corrections that need to be made to that report?
Judge, the only corrections we have is the jail credit. It will be 79 days. That should reflect throughout the report. That's the 79 days of jail credit. I spoke with Mr. Haven as well. I think he's in agreement in modifying that jail credit as well.
Thank you. Any other corrections?
No, sir.
Ms. Cope, you or Mr. Haven, do you agree with the change? to the jail credit?
Yes, it was 34 additional days for a total of 79. And the top of the 145, the sentencing date would be today's date instead of January. So,
Oh, thank you. Any other corrections, Mr. Gurmurthy?
No, Your Honor, and we believe that the guidelines were accurately scored as well.
Thank you. Ms. Cope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Will have any challenges to the scoring of the guidelines?
No, Your Honor.
Do you have any victims that want to address the court today? I know we have one of the victims connected here on Zoom right now. Are you aware whether anyone wants to make a statement?
We checked this morning and they still indicated they were going to be present today, but not speak.
Okay. Anything that you would like to say on behalf of the people for allocation?
Your Honor, this case is pretty much summed up in the victim impact statement in the PSI. I really don't think there's anything more I can add. I think the high end of the guidelines is recommended is appropriate, and I'd ask the court to follow it. Thank you.
Thank you, Mr. Gurmurthy.
Thank you, Your Honor. Your Honor, in representing Mr. Russell, I will let the court know Mr. Russell is a very personable, nice individual to work with and was very cordial in dealing with resolving this case. I think Mr. Russell, right off the back, addressed and indicated that he realized there is a problem. He was seeking counseling before his incarceration. He was in counseling to address some of the underlying issues that he had that's brought him before the court. I think Mr. Russell will also, I know he's got a letter and he wants to read that to the court, but Mr. Russell has all along been apologetic. He's been remorseful for his conduct. Excuse me. Some of the things that Mr. Russell has said is just things that are different for him because they're out of his control. And I think counseling for him and therapy and treatment, which he recognizes he needs, is going to be important. At least he was in counseling before he was again incarcerated in Saginaw County. In Saginaw County at this time, he doesn't have any court dates or anything that has been happening with this case because I think they were waiting to see what happens here. His guidelines are 19 to 38 months. The recommendation is to the high end of the guidelines. I think given his first sentence, that would be a prison sentence, I think the court should at least deviate somewhat below the top end of the guidelines. But Mr. Russell indicates that in prison, he would be taking advantage of all the courses and classes available for him, the therapy that's available for him, because he does indicate that he wants to change his thought pattern. And then I would just ask that the court give Mr. Russell an opportunity to letter that he's prepared as well.
Thank you, Mr. Russell. Is there anything that you wanted to state for the record today?
Yes, sir. I do have a statement prepared to read if that's all right.
Yep, go ahead.
I'm ashamed to be in this position today. I'm ashamed because I have brought shame to myself, my family, my church, and my Lord. I'm ashamed because I have caused hurt and harm to a family I cared for, and in particular to a young man that I should have protected. Make no mistake, I did not plan to do what I did, but because I did not put boundaries in place and my flesh was weak when the temptation presented itself, I gave in to desires that I'd fought all my life. I neither asked for nor sought out these desires, and I can only assume they're the result of my own childhood experience. But I will not sit here and use my trauma as an excuse. Quite the contrary. I know what it did to me, and because of that, I pray daily that God will guard the heart of my victim against the lasting effects of my sin. As I sit here, I can humbly and gratefully say that my Lord has forgiven me, as has my family. I have a letter prepared to give to my pastor, to read to my church family expressing my sorrow and repentance, and I'm confident in their forgiveness as well. But due to the no contact order in place, I've been unable to express my heart to my victim and his family. There exists no words in our language to make up for what I've done. And though I wish it were, it's not possible for me to undo what I've done. To my victim's parents, I say simply that I'm sorry. I violated your friendship and your trust. I care for your family still, and I pray for you daily. It's been an honor to watch your boys grow over the last few years, but where I meant to help, I hurt, and I'm truly sorry. To my young victim, I also violated your trust, your friendship, and your person. Please don't think that you've done anything wrong. You have not. No one deserves to have done to them what I did to you. I sincerely wanted to help you walk with God, but I myself was not. You've actually helped me by speaking up. You forced me to, You forced me to admit and seek help for the problems that I have. For that, I thank you. I humbly ask you and your family to forgive me, and if not for me, then at least for yourselves. To this court, I'm deeply sorry that this matter has had to come before you. I could sit here and belabor my trauma and the shame that I've carried, but I will not. There simply is no excuse. All I can do is accept responsibility and submit myself to your God-given authority and ask you to recognize my remorse and my genuine repentance and consider my own 3 children. They are my world. I know that there must be consequences, and I am prepared to accept them. I simply ask for your mercy. Thank you.
All right, thank you. I did read through the report, Mr. Russell. I'm familiar with what happened in this particular case. I'm also familiar with your background and your circumstances. And this certainly is an egregious case. I don't believe that you didn't plan this out. I think that you engaged in this course of conduct and got this young individual alone for the purpose of doing what you did. And I base that on your previous history and the circumstances here. This isn't your first time around with these kind of charges, with this kind of behavior. And I just don't believe that this is something that you just got tempted with in the moment. I think this is an activity that you planned out. You found an opportunity to engage in the kind of behavior that you're unable to control. And you took the opportunity to victimize this young individual. So again, I don't believe that in any way this was a momentary or, lapse in judgment or just a failure to control yourself in the moment. I have serious concerns that if the court doesn't give you the maximum sentence under the guidelines, that as soon as you're released, you would attempt to engage in this conduct again. And I think you need much more than religion. I think you need some serious counseling, some therapy from some individuals who are trained to help people with the kind of problem that you have, because I don't think left to your own devices or simply appealing to faith or something like that is going to be enough for you to be able to resist these urges that you have to victimize young people. And I think without some professional help geared towards this particular problem, you're very much likely to reoffend. And again, I base that on what happened here and based on your previous history of engaging in this type of conduct, which really goes back a long time, all the way back to 1999, which was your first charge for indecent liberties with a child. So this is a long-standing issue with you. It's not something that's just arisen. And again, I think you need real help with this. And I hope that you get that either through incarceration or somewhere else. As it is, I'm going to do what I can do to prevent you from victimizing anyone as a result of this case, and that is to give you the maximum sentence. The court is going to sentence you to a period of 38 months to 15 years in the Michigan Department of Corrections. You have credit for 79 days served. The court is going to order that you comply with all Sex Offender Registration Act requirements and that you submit to GPS monitoring. I think that's absolutely appropriate under your circumstances. I think that there needs to be long-term supervision of you and where you're at and what you're doing. The court is going to order that you not have any verbal, written, electronic, or physical contact with the victim. I'm not going to mention the name here because we're broadcasting this, but that's contained within the PSI, and everyone here understands who that is, either directly or indirectly through another person, and you must not be within 500 feet of that person's residence, school, or place of employment. Court is going to order that you pay a crime victims assessment in the amount of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence. If you haven't already received it, you will be provided with an acknowledgement of your appellate rights that explains to you how to seek an appeal, as well as how to request a court-appointed lawyer to help you with that appeal. So is there anything else that we need to address for the record here today?
I would like to confirm on the record that this is lifetime GPS monitoring.
I did mention that.
Thank you.
Mr. Burr.
Nothing, Judge, I just need to address Mr. Russell regarding the appellate rights. Mr. Russell, I have your appellate paperwork here. I'm required to get that to you, so I will mail that out this afternoon. So you get it at the Saginaw jail, okay?
Yes, sir.
Okay.
All right, thank you. That's all for today, Mr. Russell. The court is adjourned at this time.
Thank you.
Our next hearing is People versus Joshua Cheex. I need to just take a short recess and then we'll go back. Go on the record in People versus Joshua Cheex. This is case number 235172. The record should reflect Mr. Cheex is present here in the courtroom today. If I could have counsel put your appearances on.
Sierra Coke can be after the people.
Thank you, Your Honor. Jason Townsen on behalf of the defendant Joshua Cheex. All right. I had a chance to review the PSI. I also received the risk assessment report, which I had a chance to review prior to the hearing today. Mr. Cheex, have you had a chance to go through the pre-sentence report and talk to Mr. Thompson about that?
Yes, sir.
Mr. Thompson, are there any additions?
Sure.
Are there any challenges to the scoring?
No, challenges.
Okay, people have any decisions?
No, Your Honor.
Challenges to the scoring?
No, I think it's scored properly.
Do you have any victims that wish to address the court today?
Yes, Your Honor. Marilyn is present.
Mr. Cheex, we can have a seat next to your attorney there. Whoever wants to come forward. All right, and then you just state your name for the record, please.
My name is Marilyn Adams.
Okay, and what is it that you would like to say?
I want to read my statement out loud for the court.
Sure.
Okay. So the first one is self-mutilation and physical abuse. I remember once when him and his friends were drinking, I was sitting next to him. He had a mixed drink on the floor and I was eating jerky sticks. I had made a joke about it being funny if I had threw one of my jerky sticks in the jar in which he had his drink in. He had told me not to, and I was already in the midst of doing so. The jerky stick had landed in the jar and it splashed onto the floor. He hit me super hard in the back of the head, and then afterwards I had laid down on his bed while the rest of them continued to drink. I laid there for about an hour and a half before they left. Josh had come back upstairs and asked me if I was still awake. I replied with yes. All of a sudden he started crying, and I got up and asked him why he was crying, and he told me he didn't mean to hit me and that he had to punish himself for hitting me. I told him he didn't need to do that. He grabbed a knife and cut his wrist deep enough to make it bleed, but not deep enough to kill himself. I sat there in bed in shock and didn't know what to do or say. Next one is animal abuse. I had gotten Josh a cat named Tiny Tom that he had named after my childhood cat Tom. I recall multiple times of him abusing that cat in some sort of way. He would tie him to the bed upstairs so he could not go downstairs, which was where the litter box was located. When Tiny Tom would pee or poop on his floor, he would hit him or slam him against the floor or wall. Josh once had thrown him so hard into the sharp corner of the wall, he had cried out a loud noise I had never heard before. I thought he had killed him or at least broken a few ribs. If Tiny Tom went downstairs, he avoided Josh and the upstairs as much as possible. He absolutely hated being around him because of how he treated him. Fear of his family because lies he told me. He had told me he didn't want me around his mom or dad because they abused him horribly. He would tell me horror stories saying his dad would beat the shit out of him until he couldn't walk, how his parents were drug addicts when he was little, and how they would stick heroin needles in his arms and burn him with cigarettes. Once when he came over to Missy's house, he had told everyone that his dad punched him in the stomach so hard it bruised his kidney because his sister had told him about being a dad. Fear to leave my home in nightmares. I'm scared to be at home alone. I am afraid he will come to my house and either injure me in some way or rape me again. I saw him in family fair once and had a panic attack in the car because I was afraid he would approach me. I have nightmares of him holding me down and raping me again. I have woken up crying because of it. I'm scared to get into a relationship with anyone because I'm scared they will treat me the way Josh did. I'm scared of the retaliation from his younger friends in school, so I'm afraid to go back to school. I quit going to school because he would guilt trip me into staying home with him. When I would say no, I need to go to school, he would get mad at me for not wanting to spend every moment of the day with him. I was scared that if I didn't do what I was told, he would punish me by harming me. Drug and alcohol abuse. Josh had introduced me to marijuana and alcohol when him and I started dating. He was high 24/7 and would get mad when he couldn't smoke. He would either steal weed from his friends or money to buy it. Whenever he drank, he would get depressed and aggressive. I remember he was drinking with the family he was living with at the time, and I was there with him. Josh was sitting on the edge of the bed and I was standing in front of him. He pulled my hips to sit on his lap, and it made me fall back. So I stood up and I told him I was tired and wanted to go upstairs. So I went upstairs like I said I wanted to. I was just on my phone and all of a sudden Josh comes stomping up the stairs screaming at me, telling me to pack all my things and call my parents to come get me. It was about 3 a.m. at this time. I started crying and I asked what's wrong, what was the sudden change? And he then proceeded to tell me I disrespected him by going upstairs by myself and that I needed to get out of his house. And he wanted to break up with me. I told him to calm down and he went back downstairs. Not even 10 minutes later, he had come back upstairs crying, begging me not to leave him. Another instance was when he came to Missy's house. He was holding Viv, talking about doing cocaine, selling cocaine to get big money. He said that in front of Vivian, me, Missy, Mimi's baby, and Gracie, which is Missy's daughters. That is all, Your Honor.
Ms. Koch, any other?
No, Your Honor.
Ms. Koch, anything that you wanted to state, work out?
Your Honor, typically at this point, I would make a statement about what happened in the case and the allegations, but in this case, we held an evidentiary hearing, which Your Honor presided over. You did a written order that we have discussing the parties' 3-year relationship and the possibility that they have the child in common, although we haven't had a paternity test. We've already discussed HIDA, so I would ask the court to sentence as the court feels is appropriate. Thank you.
Townsen, anything on behalf of Mr. Cheex?
Yes, Your Honor, I do think it's an appropriate recommendation. I know the court has spent considerable time on this case. Did have an evidentiary hearing. The court is familiar with the individuals involved. I think that strikes me as middle-aged person is just how young these individuals are. Mr. Cheex presents to you as a very young man. The individual who just spoke is even younger. They have a very young child together. This is a circumstance when I speak with Mr. Cheex, I'm struck by how young he is. I find that we talk about things that make sense when you're just starting your life out, which is really what he's doing. We spent a lot of time talking about his responsibilities now that he is a man, now that he is a father, how important it is to be law-abiding, how important it is to be employed and providing for people who you are dependent on you and fulfilling your responsibilities. Mr. Cheex, again, he's very young, so he's learning these things, but he has a great desire to fulfill those responsibilities as a man, as a father. He's very sorry about this situation that brings him in front of the court. He's very sorry for everything that occurred, Your Honor. The court here heard testimony. The court has reviewed the assessment. Mr. Cheex is committed to moving forward and following the law, doing things in the right way, Your Honor, to providing for his child. And that is his intent, Your Honor. I think Home's Youthful Training Act is appropriate here because it does give him an opportunity to demonstrate to the court that he is capable of stepping into those shoes of manhood, of being a responsible individual, and of becoming a productive citizen, and of becoming a responsible father. So he's asking the court for that opportunity. I think this is exactly what Home's Youthful Training Act status is for. It's for individuals who are very young, who are still forming. All the evidence in neuroscience is that at Mr. Cheex's age, the brains are not yet formed. He still has brain maturation to do. The actual physiology of his brain is not yet mature. And I think with guidance from probation, guidance from this court, and probation status, I believe that affords him an opportunity to prove himself, and also for the court to monitor continue to assess this situation and continue to determine if Mr. Cheex can fulfill those responsibilities and if he remains deserving of that home vehicle training act status. So that is our request, Your Honor. We are asking the court to adopt the recommendation. Thank you.
All right, thank you, Mr. Cheex. Anything that you wanted to say today?
No, Your Honor.
I'm sorry.
No, Your Honor.
Okay, thank you. All right, I did have a chance to review the pre-sentence report, and so I take all of that information into account. Obviously, I heard from the victim today, and again, I want to thank you for making that statement here. I know that's not easy to do, and it's always important, I think, for victims statements to the report so that we get your perspective on it. So I appreciate that. As counsel indicated, I have really good understanding of the facts of this case based on previous proceedings that we've had. We had a lot of testimony regarding what went on between you and the victim in this case. And so more than in some cases, I think I have a really good feel for what went on between the two of you, at least as far as I can tell from the testimony. And I think this was really a dysfunctional relationship right from the start. I don't think there's any question about that. I think there's a lot of things that went on between the two of you that didn't need to happen, and were probably driven by your use of substances, certainly. But I also have to recognize that you two were both really young, both of you at the time when it started, and really throughout the duration of this relationship, and that you're still a young man right now. And I have to believe that your age had a role in this, your lack of understanding of what a healthy, normal relationship would be, what the proper way to treat another person in that relationship. And I think a failure on your part to really understand how substances can affect your behavior and how it lead to really poor behaviors and behaviors that result in harm to other people, either physically or psychologically. And again, you're 20 years old. I hope you do take this seriously, and I hope that you use this as a learning mechanism to understand that substance abuse is only going to lead to more problems for you. And now is the time at your age to get a hold of that before it gets out of control and it becomes a bigger problem than it already is. Balancing all the factors here, and again, I think age here is really a compelling factor to the court. I do think that the height of probation is appropriate. I think this is exactly the kind of circumstances that's designed for. To recognize that people who are younger do not make good decisions, don't understand sometimes the full consequences, and gives them an opportunity to correct their behavior and get on the right path going forward. And that's going to be up to you going forward, whether you want to take that opportunity to do that or not. I do think that a short jail sentence at the beginning, again, to provide a degree of consequence to you, so that you understand that type of behavior that you engage in here is not acceptable, and that there's for that, to impress upon you the importance of that. The court is going to hold some jail time in abeyance too over your head as a motivation for you to comply with probation and not engage in this behavior anymore. And again, the ball's in your court. Either you straighten up, do things the right way, and if you don't, then there'll be more jail time on top of it. The guidelines in this case are 0 to 14. The court is going to sentence you to 9 months in the Crawford County Jail. The court is going to order that to serve 3 months of that up front. Or to hold the remaining 6 months of that in advance. You serve at the discretion of the court. So if you mess up while you're on probation, I can impose any or all of that additional 6 months immediately. If you not pass go, straight to jail. And that would be in addition to potentially losing that height status and additional penalties for violating probation. There's a significant consequence if you don't comply. So again, 9 months with the first 3 months up front. You have credit for 2 days served. The court is going to order that you placed on probation for a period of 3 years pursuant to the Homes Youth Act. The board is going to adopt the conditions of that probation, all the terms and conditions listed in this report. Primarily, as part of that is you are not to have any verbal, written, electronic, or physical contact with Marilyn Adams without permission from your probation officer, either directly or through another person. You must not be within 500 feet of her residence, school, place of employment. I understand that there may be some issues regarding the child that you potentially share employment. Again, the provision is without permission from your probation officer. So if there are legal proceedings that need to happen, I'm sure the probation officer will make arrangements to be able to do that. But otherwise, you're not to have any contact with Ms. Adams, along with all the other terms and conditions of your probation. The court is going to order that you pay $325 court costs, attorney fees of $350, state costs of $68, probation supervision fee of $30 per month, and a crime victims assessment of $130. Because this sentence is pursuant to HIDA, there are no written appellate rights. So, is there anything else?
No, thank you, Your Honor.
Nothing else for the record. Thank you, Your Honor.
All right, so Mr. Cheex, you're going to go with the observation. Townsen, you ready on this Ramsey's case?
Yes, sir. Thank you.
People versus Angelica Ramsey, case number 235251.
Here, Coke, on behalf of the people.
Jason Thompson on behalf of the Angelica Ramsey.
Ramsey, you come here, podium. This is the date and time set for sentencing in this case. The record should reflect that I did receive a report from Ms. Anderson at pretrial services. It was also provided by Mr. Townsen prior to the hearing today. A number of support letters that were submitted on behalf of Ms. Ramsey. I did have a chance to review all of those as well. I have counsel for your appearances on that.
Sierra Coke, on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant Angelica Ramsey.
Ms. Ramsey, have you had a chance to go through the three-sentence report and talk to Mr. Thompson about that?
Yes, Your Honor.
Mr. Thompson, are there any additions that we should correct?
No, Your Honor.
Are there challenges in scoring the guidelines?
No challenges.
So are there any additions?
No, Your Honor.
Challenges to the scoring?
No, Your Honor.
One thing I do want to mention, I was notified by probation prior to the hearing. The PSI indicates the recommendation of 5 years of probation. They indicated that should be 2 years. That's correct.
Yes, that is correct, Your Honor. I forgot to mention that. Yes, I was advised of that by the probation department. I agree. That's appropriate.
Thank you, Ms. Coke. Anything on behalf of the people for
Your Honor, this case is hard because frankly, I've had a lot of contact with Ms. Ramsey through my professional position here as the prosecutor. And she was doing really bad for a long time. We saw her pretty regularly, and then she sort of disappeared off the radar. She came back for this case. And this is one of those cases where she made a choice. I don't personally buy, my opinion doesn't matter, but her story in the PSI, she made these choices. She contacted both courts repeatedly. Mr. Wilson, her boyfriend at the time, had felonies here and in Roscommon, and everybody was trying to get them scheduled for trial. And there was issues in district court, and she was contacting everybody, telling them about this fake police report or this fake hospital. In fact, Mr. Haven tried to call her out on it and say, hey, we tried to call and verify this. She took it another step further and said, well, it's because of his brother. That's why they had to put this secret thing in at the hospital. And she and just kept going on and on about it. It was all a lie. Every part of it was a lie. We ended up having to have Michigan State Police go to the hospital, speak to the doctor had the fake signature on the letter, and do a whole MSP investigation into this because we were trying to get all the other cases resolved. But with Miss Ramsey contacting everybody and making up all these stories, there was hours and hours of time put in by multiple different courts as a result of this. And frankly, I think she should be punished. Her guidelines are high because of her history. And I don't think the CMH diversion is appropriate. I think she should be scored within the guidelines, just like everybody else. I do think she probably needs the mental health services when she's done with jail. Thank you.
Your Honor, Ms. Ramsey had asked if she could confer with me before she speaks. She just raised that with the prosecutor. So I don't know if the court would.
I'm not gonna take a break. You guys want to talk for a second there, counsel? Mr. Townsen, anything on behalf of Mr. Ramsey?
Yes, Your Honor. I mean, first of all, Ms. Ramsey's here with the offense of harboring a felon. She's not here regarding sentencing offense. It's not any kind of this false statement. I think that's true to Mr. Wilson. Mr. Wilson is the person who had something to gain from this. He was the individual who was directing this. The court service familiar with Mr. Wilson. You can see Ms. Ramsey, I think her physical stature is kind of exemplifies the nature of their relationship in terms of who's the individual making decisions in that relationship. This is Mr. Wilson's operation. This is his case. Ms. Ramsey went along with it. She's not the first girlfriend to do something legal. This boyfriend told her it was a good idea or it would help him. Asked her to she's here. She pled guilty to harboring a felon. She is guilty of that. She accepts that the court is going to impose a sanction on her today. I would ask the court to consider that this is again his case, his operation, by operation, or whatever you want to call it. I'm referring to a fake medical procedure, but this was his thing, and she did help harbor, and she apologizes for that. She recognizes that's illegal. But Your Honor, what the prosecutor goes on about what Mr. Wilson was having submitted to the court, that was his scheme to try to avoid this court and other courts. Ms. Ramsey, she does score fairly high, but it would be hard to get 50 points on PRV with the skinnier record. She's got one possession of meth, which gets 25 points on the PRVs. She's got some misdemeanors that count, like shoplifting. She's got 2 prior low severity felonies that are very low severity. So she got 50 points on the PRV. I don't have a legal objection to that, but I know the court has seen far worse records generate a 50 on the PRV. The recommendation is 10 to 23. I think the 10-month jail sentence, I question the efficacy of what can be accomplished in the Crawford County Jail in 10 months. It's not a facility that's designed to rehabilitate. It's a facility that's designed to house people, essentially pending trial and for short jail sentences. So I do question that aspect in terms of just what our jail is set up to do. Ms. Ramsey, again, takes responsibility for harboring a felon and acknowledges her culpability in that regard, but asks the court to consider the relative wrongdoing of the 2 people involved in the situation. Thank you.
All right, thank you, Mr. Ramsey. Anything that you want to say?
I don't know because I don't have the paper, but I know it is in the system, like there's, in Troy's PSI, it does state that they could not prove who sent the emails. So I feel like that's why neither of us are facing any charges as far as falsifying anything, we can prove it. So I don't know if I just want to make a point to put that out there. I don't know, I just don't want something that I'm not facing being used to towards the judgment of what, like a totally different charge that I am facing. If I had that charge against me, I'd understand like why we bring it up. I don't know how it works.
I did read through the report, so I'm familiar with what happened in this case and your involvement with Mr. Wilson. I'm certainly familiar with Mr. Wilson. I had cases in front of me here and other counties as well. Certainly not the type of person that you want to be involved with if you want to stay out of trouble, because he's in plenty of trouble a lot of the time. So I understand the circumstances here. I also had a chance to review the report in terms of your past record and your circumstances. And as Mr. Townsen indicated, the guidelines call for a sentence of up to 23 months in prison in this case. So your guidelines range quite high. And that's partly because of your past history. And while I don't disagree with Mr. Thompson's characterization of your past record, it doesn't involve any violent crimes or anything like that, but certainly you've had enough involvement with the criminal justice system to know when you're going to get in trouble for something and when you're not. And regardless of your relationship with Mr. Wilson, it's hard for me to think that you didn't know that you were going to get yourself into some kind of trouble by doing what you were doing. Trying to help him. And so you have to take responsibility for that. That's on you regardless of anything else that's going on. I do think there are some mitigating factors here based on, I'm sure that Mr. Wilson was very good at convincing you to do some of the things that you did, and if it weren't for that relationship, you may not have engaged in conduct. And so I think that does provide the court with a basis for sentencing you at the low end of the guidelines, but I don't see any kind of mitigating factors here that would convince me that it should be less than the bottom end. So again, the bottom end is 10 months. I think that adequately accounts for your conduct in this case. I think it provides a punishment and consequence to you. I think hopefully it also provides a deterrent fact that other people are going to engage in this conduct. They understand that there's a consequence to it. That there's a punishment. So the court is going to follow the recommendation here. The court is going to sentence you to probation for a period of 2 years. The court is going to adopt as the conditions of that probation all the terms and conditions that are listed here in the report. The court is going to order that you serve 10 months in the Crawford County Jail. You have credit for 24 days served. Crime victim's assessment of $130, court costs of $325. Attorney fees of $350, state cost of $68, assessment of $130, and supervision fee of $30 per month while you're on probation. You do have the ability to seek an appeal of the sentence, and Mr. Thompson provide Mrs. Ramsey with her appellate rights. Just go ahead.
Then you're going to take 2 of these. And if you wanted to file an appeal, these would be paperwork that you would use to start it. So this is just acknowledge receipt of filing an appeal.
Mr. Thompson, the court's going to attach those letters to the PSI.
Yes, you are. Thank you.
Judge, I'm gonna date her paperwork for her.
Thank you. Mrs. Ramsey, you already.
Your Honor. That's going to be if the court would consider allowing the jail sentence to start in 7 days as opposed to today.
No, Mrs. Ramsey, still in the custody right now. Townsen, your next case is with Mr. Green. Are you ready?
I believe so, yes. Stay at the podium, maybe. We can go this way over.
I just want to recess on court officer.
Oh, yes, certainly, Your Honor.
Just gonna take a break and then we'll be right back. We're on the record in People versus Green. The record reflects Mr. Green is present here in the courtroom today. I'd like to have counsel put your.
Here, okay, we have the people.
Thank you, Your Honor. Jason Townsen on behalf of defendant Charles Green.
Mr. Green, have you had a chance to go through the pre-sentence report? Speak to Mr. Thompson.
Yes, well,
More time to do that before we.
yes, please.
Well, I guess we will take a little break here.
All right,
Take
thank
about
you.
5-minute break and then we'll be back.
Thank you.
I think both 10:45s are on Zoom.
Yes. We have it ready.
Perfect.
All right, Mr. Worden, are you able to hear me okay?
I am, Your Honor. Thank you.
All right, we're on the record in People versus David Yankee. This is case number 235276. The record should reflect that the defendant is present by Zoom by prior approval of the court. His counsel is also present by Zoom. Mr. Worden, we have Ms. Pope present here today. Mr. Worden, this is set for a status conference. Can you tell me how you and your client went?
Yes, Your Honor. Based on a revised plea offer, Mr. Yankee will be pleading guilty to attempted flee and elude fourth degree of 1 year maximum misdemeanor. In exchange, the balance would be dismissed, and he would like to take advantage of that plea offer.
Okay, and Mr. Worden, I'm going to go through the procedural aspects, but are you prepared to take a factual basis from your client today?
I am.
Okay. Ms. Pope, is that a correct statement of the plea offer?
It is, Your Honor.
Mr. Yankee, have you had a chance to discuss this plea agreement with Mr. Worden?
Yes, I have, Your Honor.
And is that how you wanted to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help me God.
Yes, I do, Your Honor.
Thank you. You can lower your hand. Sir, are you currently on any kind of probation or parole?
No, Your Honor.
And you understand that by pleading guilty to attempted fleeing and eluding fourth degree, that is a misdemeanor that carries with it a maximum of up to 1 year and or a $1,000 fine and a suspension of your driver's license.
Yes, Your Honor.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty, Your Honor.
Right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, Your Honor.
You understand that you're going to be giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here on the record today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
Okay, Mr. Worden, if you could conduct some questioning of your client to establish a factual basis.
David, on September 30th of 2023, were you in Crawford County?
Yes, I was.
And you were with friends operating side by sides, true?
Yes.
And were you pulled over by police?
Yes.
And were they in a fully marked vehicle with lights and sirens?
Yes.
And you knew you were pulled over?
Yes.
And you knew you weren't free to leave?
Yes.
And instead you got on the gas and sped away and fled from police?
Yes, sir.
And you did not have permission to leave? You knew you were stopped at that point?
Yes, sir.
And again, that happened in Crawford County?
Yes.
I think that's sufficient, Your Honor.
Ms. Koch, are you satisfied with the factual basis?
Yes.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
There's an unrelated civil case for forfeiture. It's not part of the plea agreement, but we've agreed to dismiss that. And we have gotten a signed dismissal form. We've submitted both the amended information in this case and the unrelated civil forfeiture. Nothing other than that, Your Honor.
Okay. Mr. Worden, are you aware of any other threats, promises, or inducements other than what's been placed on the record?
I agree with Ms. Koch, and no, I'm not.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Worden?
Yes, Your Honor.
Thank you. Mr. Yankee, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. Mr. Worden, have you talked to your client about whether he wants to have that in person, or I don't know if he's in a treatment facility or what's his circumstance?
No, Your Honor, he is in LaGrange, Indiana. This was a vacation to the Grayling area when this occurred this past fall. I think he and I are of the same mind that we should probably be in front of you in person for sentencing.
Yes. Okay, good. I think that's a better situation as well. So the court will set this for an in-person sentencing hearing. Mr. Yankee will notify you of the date and time of that hearing along with your attorney. Prior to that, someone from the probation department will be in touch with you for a pre-sentence investigation. And we just want to get this contact information.
You can provide his phone number, Judge.
Okay. Mr. Yankee, can you give us a phone number where the probation department can contact you?
Yes, I can. It's 1-260-336-2683.
Okay, thank you. Mr. Worden, anything further from your side today?
No, Your Honor, thank you.
No, Your Honor.
All right, Mr. Yankee, just make sure you follow up with that phone call from probation when you get that, and then you stay in touch with Mr. Worden. That's all for this hearing today, and all parties on this case are free to disconnect.
Thank you, Your Honor.
Thank you, Your Honor.
Mr. Davis, are you able to hear me all right?
Yes, good morning, Your Honor. I can hear you fine.
Okay, good. Mr. McOscar, are you able to hear me?
Yes, sir.
We're on the record now in People versus Chad McOscar. This is case number 235275. The record should reflect that we have both parties present by Zoom by prior approval of the court. This is set for a status conference today. Mr. Davis, how do you and your client want to proceed?
Judge, there was an offer tender of attempted fleeing and eluding 4th degree. Client not prepared to accept that offer, Judge.
Okay, Ms. Polk, is that a correct statement of the plea offer?
It is, Your Honor.
And Mr. McOscar, have you had a chance to talk to Mr. Davis about this plea agreement?
Yes, Your Honor.
And is that how you wanted to proceed today?
Yes, Your Honor.
Okay. And Mr. Davis, I'm going to go through the procedural aspects of this plea with Mr. McOscar. Are you prepared to take testimony for a factual basis when it's time for that?
Yes, I am.
Okay, thank you. Mr. McOscar, can you raise your right hand, please? Do you solemnly swear or affirm? There you go. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. McOscar, are you currently on any probation or parole?
No, Your Honor.
Right, and you understand that the maximum possible penalty that you could face for this charge, which is attempted fleeing and eluding 4th degree, is up to 1 year and/or a $1,000 fine and suspension of your driver's license.
Yes, Your Honor.
With that maximum possible penalty in mind, what is your plea to that charge today?
I'm sorry, Your Honor, what was that?
How did you want to plead to that charge today with that maximum possible penalty in mind?
Guilty, Your Honor.
All right, as I want to make sure that you understand all of your rights. You understand that you have the right to have a trial, the right to have a trial by a jury, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have any witnesses against you appear at trial and to question those witnesses, the right to have the court order any witnesses on your behalf appear at trial, the right to remain silent during a trial and to not have that silence used against you, the right to testify to trial yourself if you want it. You understand that you have all of those rights?
Yes, Your Honor.
Understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here on the record today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
What was that, sir?
Are you pleading guilty to this charge because you are in fact guilty?
Yes, Your Honor.
All right, thank you. Mr. Davis, I'll ask you to conduct some questioning of your client to establish the factual basis.
Yes, thank you, Your Honor. Mr. McOscar, I would like to direct your attention to September 30th, 2023, when you in the county of Crawford.
Yes, sir.
You were operating a motor vehicle, is that correct?
Yes, Your Honor.
And you were given signals by an officer, Michael Wells and Scott Clark, indicating that you were required to pull over and stop driving that motor vehicle. Is that correct?
That is correct.
Okay, and you disregarded those signals and kept driving, increased your speed, and attempted to get away from the officers. Is that fair to say?
Yes, sir.
All right, I'm satisfied.
Ms. Koch?
I'm also satisfied, Your Honor.
All right. Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
Similar to the last file, it's an unrelated case, but because they're entering a plea in this case, it is my understanding that the forfeiture action will be dismissed. I'm just putting that on the record. We filed the amended information in the criminal case. Nothing further, Your Honor. Thank you.
Thank you. Mr. Davis, are you aware of any threats, promises, or inducements other than what's been placed on the record?
No, I'm not.
Are the people satisfied that the court has complied with statute and court rule in taking this plea?
Yes, Your Honor.
Mr. Davis, are you?
Yes.
Thank you. Mr. McOscar, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. That hearing will be set in person here in Crawford County. So make sure that you stay in touch with your attorney. Also, prior to that hearing, someone from the probation department will be in touch with you for a pre-sentence investigation. Can you give us a phone number where they can contact you at?
Yes, Your Honor. It's 517-416-9152.
Thank you. So just make sure that you follow up with that call when they contact you. And then again, as I said, make sure that you stay in touch with Mr. Davis. Mr. Davis, anything further that we need to address on this file today?
Nothing further. Thank you, Judge.
Oh,
Nothing further. Thank you, Your Honor.
okay, that concludes this hearing and you're both free to disconnect at this time.
Great. Have a good day.
Thank you.
I need to take about a 10-minute recess and then we'll be back on the record with Mr. Green's case and the rest of the. We're on the record in Michael versus Green, case number 235273, again, record reflecting 37 here. Mr. Green, did you have an opportunity now to speak with Mr. Thompson?
Yes, sir, thank you.
Okay. And Mr. Thompson, are there any additions, deletions, or corrections?
No, Your Honor.
Are there any challenges to the scoring?
No.
Let's go. Do you have any additions, deletions, or corrections?
No, but we do have a victim that would like to speak, as I understand it.
Do you have any objections to the scoring?
No.
Mr. Green, if you had a seat next to Mr. Thompson, just go ahead and. You have your- Morning, ma'am. Can you just tell me your name?
My name is Maria Watson.
Okay, thank you. What is it that you would like to say today?
I would like to say that I know this case is important and I understand all the legal things about it. I'm asking for like the restraining order to be lifted. And so that we could get going on our business again. I mean, we have a business, we've been in business for 4 years. And with him gone, it's putting me at a hold. And that's just my part of that.
Thank you.
Thank you.
Mr. Green, you can come back up to the podium. Ms. Coke, anything that you want to say on behalf of this people for outreach today?
Or I think the facts are set forth in the PSI. I'm aware the court reviewed that. I don't have anything further to ask. I'd ask the court to follow the recommendation.
Mr. Thompson.
Thank you, Your Honor. Mr. Green is very sorry about what happened. He regrets it very much. I've talked to him several times. It's apparent to me that what happened is he drank too much. And beyond that, quite frankly, his memory gets very fuzzy. That's because he drank too much. And bad things happen that he's taking full responsibility for. Even though he doesn't directly remember everything that happened. He accepted it. I'm very sorry about it, Your Honor. And again, that happened because he drank too much. He drinks. Points lacking out, which is what happened here. When he drinks, he is capable of violence. Of course, in his past. That's sort of the bad news. The good news, though, from Mr. Green's perspective and thinking about sentencing on this, he has done well on parole before. He has done well on probation before. He has stemmed that tide of drinking too much and being violent. Where you see those from past events, they're far in the past. He had a relapse. He had a moment in the evening where he did not live up to the standards he had been setting for himself. And the new path he had put his life on. And he's very sorry about that. He's very sorry to the victim. He's very sorry to the court and community, Your Honor. He is asking that the no contact order be lifted. He understands he has to serve some punishment. He believes if he can have contact while he's incarcerated, that can help begin whatever healing process the two individuals want to go through. Any concern about public safety, because he'd be incarcerated. This isn't a situation where this is a long-standing, controlling type of relationship. This individual drank too much. Bad things happen when he drank too much, and unfortunately, he's got a record that this lesson's going to get hammered home in a fairly severe way. It's not that he hasn't earned that. It's just. He wants the court to consider that he has done well in probation. He is committed to not drinking like that anymore. His responsibilities, and he's asked the court to consider all that in light of fashioning a sentence. Thank you.
All right, thank you. Mr. Green, was there anything you wanted to
I'd
say?
like to add that I'm an alcoholic and I take full responsibility for what I did, and I definitely drank too much that evening. That is my fault.
All right, thank you. I did read through the report, so I'm familiar with what happened in this circumstance. There's also a lot of information in that report about your past history and so forth, which does contain a number of incidents like this. So this isn't your first time in that. Of course, there's also some guidelines which you could call for prison. So I don't think that's warranted given the circumstances here, but Obviously, you're gonna have to serve some jail time as a result of this, and I think that's appropriate. I think you need to understand that if you are gonna make that mistake of drinking, that there's gonna be consequences, and those are only gonna go up from here. I think if this happens again, you're probably looking at prison, no matter what.
Certainly.
So if you wanna avoid that, this is really your last stop to do that. So I do hope that you comply with your probation. I hope you get whatever treatment you need to avoid your problem with alcohol to help you deal with it. Because if you don't, again, I think you know now what the consequence of the next incident is going to be. In terms of what should happen in this case, I do think the recommendation is appropriate. I think it accounts for your conduct here. I think it recognizes your past history and your failure to correct your behavior over time. The court is going to follow that recommendation and sentence you to probation number 1 for a period of 2 years. The court's going to adopt as the conditions of that probation all the terms and conditions listed in the report, which includes that you not use or possess any alcoholic beverages or other intoxicants, that you complete any mental health or domestic violence intervention or other recommended treatment. The court is going to order that you serve 12 months in the Crawford County Jail. You have credit for 1 day served. I don't have a problem with you having contact with the victim in this case while you're in jail. Once you're released, I'm going to leave that to the discretion of the probation agent. See how those contacts go while you're in jail. If the probation agent feels that that that's acceptable based on the way things have gone while you were in jail, then they can allow it, and if they don't, then they won't. So a lot of that's what you have to do as how you go forward. The court is going to order a crime victim assessment of $130, court costs of $325, attorney fees of $350, $68 state costs while you're on probation. Also, it's $30 per month. You have the ability to seek an appeal of this sentence, Mr. Townsen.
Yes, Mr. Green has his copies of the appellate rights, and we had acknowledged copies of the court file.
Okay, further for the record.
No, Your Honor, thank you.
Nothing further.
There's so no contact order is listed though?
While you're in jail, and then after that, you have to get a probation. Versus David Burr, case number 235200.
Sierra Coke on behalf of the people.
And we're on behalf of David Burke, who was present. Any appointment?
The date and time set for sentencing in this matter. Mr. Burr, have you had a chance to go through the recent report?
That's this document here. Yes.
Okay. And Mr. Vernon, I did receive your memorandum. Ms. Pope, did you really copy that as well?
I did.
Do you have any objections to any of the factual changes requested?
No.
Court will order, and Mr. Vernon, by that probation.
I'm happy to.
Court will order that each of those corrections be made. Prosecutor. Aside from those changes, Mr. Vernon, were there any other factual changes?
No other additions, deletions, or corrections.
Any challenges to this wording of the guide?
No.
So, do people have any additions, deletions, or corrections?
No, Your Honor.
Do people have any challenges to this one?
I believe it's scored properly.
Do you have any victims that wish to address the court today?
The victim's father is present but does not wish to address the court beyond the statement that was already provided to the court.
All right, and are you the father? Yes, sir. I did have a chance to read that prior to today's hearing. Thank you, Your Honor. Ms. Coke, is there anything that you want to say on behalf of the people for allocution?
I'm familiar with Mr. Burr's family. He comes from a well-respected family in this community. as does the victim. When I read the PSI, one sentence really stuck out and I wanted to read it. When Deputy Becca asked him why, he said, "She showed me her pussy and I wanted to touch it. I touched it over the pants and she looked at me with a smile on her face. I don't know. The words going through my mind is estrogen and pheromones, but she is 13. Mr. Burr was a member of her family, had a trusted relationship with this 13-year-old. I think he abused it by what he did. I think the recommendation is appropriate, if not low. And I don't think HIDA is appropriate. Thank you.
Mr. Vernon?
So, Your Honor, we are asking the court to impose HIDA, or to grant HIDA, I shouldn't say impose, to grant HIDA in this matter. The penalty under HIDA is a 25-year period of registration. As we've identified these things in our sentencing memorandum. Mr. Burr has acknowledged and continues to acknowledge that what he did was wrong and inappropriate, and some sort of penalty is appropriate. We think the recommendation from probation for the 90 days jail is an appropriate penalty. We think a period of probation at 2 or 3 years, my client would agree to the third year. The penalty of an additional 25 years of registry for, again, what is clearly inappropriate behavior seems excessive. And we're asking the court to consider the imposition of HIDA so that at the conclusion of a successful probation, the penal components of the HIDA or of the SORA requirement could be lifted. I think that with a long period of probation, the court could supervise Mr. Burr. He is already engaged in services. We have provided, if I may approach. Yes, we gave copies to her. Those are some letters of support from the community. There are folks from the community here from his church. His parents are here. His mom's actually in the parking lot. She has just tested positive for COVID and didn't want to come in. But his family is here. The mother of his children, Katie, who is the older sister to the victim, is here sitting with Mr. Burr's family and supports him in his progress through this matter in an attempt to save their family. I think that with that support system in place, with the acknowledgements that he has made as to his wrongdoing, I think that HIDA is an appropriate way to address this matter. I think one of the things that I'd like the court to consider, I don't want the court to make, I don't want us to make it sound like we are making excuses, but I think it's a background in the history that Mr. Burr, one, has not fully realized himself, but is certainly consequential in this matter. Mr. Burr has identified that he had been sexually assaulted on several occasions when he was a child. There was never any treatment or counseling or any way for him to deal with that. And as comes before you very often, people will deal with those types of traumas in inappropriate ways, usually through drugs and alcohol, which he has admittedly attempted to use essentially as self-treatment. He has recently, and as you can see from the letters, engaged with the church for counseling and other services, and has found a much healthier path forward. I think because of that, the services that the court can provide through probation would be very helpful in addressing not only the sex offender treatment as a perpetrator, but as a victim as well. So I think those services are all something that will benefit him a great deal. I think that the court takes all of these things into context. The appropriate remedy does not include a 25-year registration period. So we're asking the court to consider those things and impose the penalties as recommended under the PSI, but also subject to HIDA.
Thank you. Mr. Burr, is there anything that you wanted to say?
Yes, I wrote a statement. First, I'd like to apologize to Allie Ray. I'm sorry for my behavior. You're a great young lady and did not deserve such physical contact, and she's not here, so she didn't hear that. I'm sure it'll be said there. I'd like to apologize to the whole Morrow family who has had a 5-generation-long relationship with my family from Allie Ray's great-grandmother Kay, her grandma Heidi, and her great aunts and uncles, including her father Greg Morrow. Greg, I'm sorry that I broke your trust in me. You trusted me with your daughter's hearts and I crushed them. As a father and a victim, I completely understand the repercussions of my actions and the effects that this will have on the bond of our families. I'm truly sorry. I would also like to apologize to Katie, whom I love and am thankful and grateful to have a long-standing relationship with for most of the past 8 years. The mother of my children. I've disrupted the relationship you have with your stepdad and your sister for the rest of your lives, and they will forever be changed. Since we have children together, it will change family events, outings, and everything as long as the children are here. I hope they're always accepted and never judged or treated differently for my actions. Rael and Poppy, those are my 2 daughters, who I owe the biggest apologies to. I'm sorry to my sweet, young, and beautiful daughters who do not know or understand yet, but one day they will, that what I've done is not in any way appropriate or acceptable behavior. I stand here as a much kinder, gentler, and humble man compared to the man that I was almost a year ago. I would also like to thank my Lord and Savior, Jesus Christ, through him with the help of my pastor, Dave, along with counseling, support from my family, and especially Katie being able to be there for her and for my children. Without them, I don't know where I would be today. Probably not standing here as the magnitude of my actions were devastating. I felt as if my life was completely and utterly over. After a couple hours of speaking with my family via telephone, I went to their home and turned myself over to the authorities, gave a truthful statement, a confession of my actions. Regardless of that, Mr. Morrow was at my parents' house with a gun, not only threatening my life, but theirs as well to get to me. As a victim myself, for the first time, being at a very young age, I started to use and abuse substances to fade my memories, which is no excuse for my actions. I take full responsibility of my actions today to stand here in front of you, Your Honor, after pleading and admitting my guilt. I believe I shouldn't be on the registry for 25 years because that will forever affect the relationship and the time I'm able to spend with my kids. I'd like to be able to come to events they invite me to, are invited to, and never have them looked at different. I'd like to go to daddy-daughter dances, make crafts, go to the little movies they'll have at the school. I'd like to be involved as much as I can, since they will already be spending so much time away from me. I never want them to feel like I didn't want to make it or like daddy couldn't go because I wanted to be present. With that being said, I have provided a risk assessment which came back low. I believe wholeheartedly that I've learned my lesson. I believe the Homes Youthful Trainee Act would be a better option for my sentencing.
Thank you.
You're welcome. Thank you for letting me speak.
Welcome. I did review the report. I'm familiar with the circumstances here. We've had a number of different hearings. I've had a chance to go through the facts a number of different times based on the different proceedings that we've had. So got a good handle on the circumstances here. What's your background, your circumstances? I did read through the reports that were submitted by your attorney, your assessment. And so taking all of that into account, the court has to look at what is an appropriate sentence here. What can the court do? Number one, to punish you and provide a consequence to you for your actions in this case. What can the court do to protect our community in terms of what's going to happen going forward? What's necessary to prevent you from reoffending, prevent anyone else from being a victim? What can the court do in terms of rehabilitation to help you with that so that you don't reoffend? The court tries to come up with a sentence that addresses all of those components. And in this case, I think there's a combination of things that we need to do to address each of those 4 different things. Number one, in terms of punishment, I do think there needs to be a jail sentence. Spend some time in incarceration so that you understand that if you do reoffend, there's going to be more of that. I also think that the community needs to see that this type of behavior is dealt with in a serious way, as well as taking place in these liberty for a period of time. I do think that in terms of what can we do going forward to protect the community. I did read through the assessment. I'm sure that that person did a thorough job of determining what they think about potential that you may reoffend. From my standpoint, I have some concerns. This doesn't appear to me, as I look at the facts, it looks to me like you took advantage of a circumstance that you had a strong enough urge to do what you did that you were willing to put aside the relationships that you knew would be harmed by those actions. And that causes concern to me when people are willing to forego negative consequences in order to satisfy what they want to do at the moment. To me, that tells me there's a problem there with urges that you may not be fully able to control, and something that we need to monitor as a community going forward to make sure that you're not presented with those opportunities again. And so I don't think HIDA is appropriate. I think this is the type of crime that needs to stay on your record so that people going forward can have some idea that this might be an issue with you. So I don't think that's appropriate. And again, I think for the protection of the community going forward, it's necessary that this remains on your record. That you can subject to some monitoring going forward. In terms of rehabilitation, I think probation is an appropriate way to address that. I think through probation, you can be provided with some resources that will help you deal with those types of urges that you have, help you deal with your background and things that have happened to you in your past that may have led to your substance use and behavior in this case. And I think the more you can get help with that, in addition to the monitoring going forward, the more that we can ensure that this isn't going to happen again and that we aren't going to have any more victims. So the court is going to follow the recommendation in terms of probation. The court is going to place you on probation for a period of 5 years. The court is going to adopt as the conditions of that probation all the terms and conditions of the court. The court is not going to make that probation pursuant to HIDA. The court is going to order that you serve 6 months in the Crawford County Jail. You have credit for 2 days served. Crime victims assessment of $130. Court costs of $325. State costs of $68. The court is going to order that you pay $30 per month for a supervision fee while you're on probation. You do have the ability to seek an appeal of this sentence. Mr. Vernon will provide. As Mr. Burr acknowledges, he did. Ms. Pope, is there anything further that you want to address?
No, thank you, Your Honor.
No, Your Honor.
Just so you know. I don't have your number. Just tell them you want to call me.
I'll see you guys. Praise the Lord. Sure.
Siri. We'll get these changes made.
Okay, thank you.
Okay.
Townsen, let's go.
Record versus Marvin Townsen, number 235215 and 5216. The record should reflect Mr. County present here today.
Sierra Coke on behalf of the people.
Okay, now we're gonna go with Townsen, who's the state candidate.
This is the date and time set for sentencing in this case. Mr. Townsen, I did receive today a motion that you submitted to withdraw your plea. Is there anything further you wanted to say?
Sorry. No, Your Honor.
Okay, but there's only certain circumstances where you'd be allowed to withdraw the plea prior to sentencing once it's been accepted. Your motion doesn't list any of those circumstances. The fact that you're not happy with Mr. Mertz's representation, or the fact that you're just rethinking your decision to plead no contest, is not a reason to withdraw.
Okay, then I will say something. I don't, after receiving the PSI late, that was due to the incompetence of my lawyer. Because knowing how mail works, I guess, and that's what I sent. That's my motion. Due to that, didn't have enough time to review the PSI, and I don't agree with 90% of it. So me pleading no contest, I feel like I need to argue my point now, and I'm the only one that can prove my innocence on either one of these cases.
It's too late for that. You already entered your plea. If you wanted to argue your case, you had a chance to do that.
I feel like I got suckered into it, so I guess I'm gonna appeal and
That's
whatever it is.
I don't think you were suckered into anything. You got a long enough record to know how this works. So
I was manipulated, yeah,
And I didn't-
by the police officers in this situation too. There is no mention of my daughter anywhere in any of the police reports. She was in the room the first day the police came. And that is the reason why I acted as such about the flashlight. And there's no mention in any of that. Now I'm just agreeing with whatever they do.
I think you're just trying to delay.
No, I'm not.
We're gonna go forward today.
Okay, but
You
you're
can have
wrong.
Mr. Gurmurphy represent you for purposes of this hearing, or you can represent yourself.
No, I don't need here.
So, Mr. Gurmurphy, I'm just gonna have you remain at standby with the case.
I was, and then just for the record, Judge, we were here back in January when the plea was entered, sentencing was set for in January, and again, due to the holiday with the way it fell, he's right, we didn't get the PSI. I didn't get it in a timely manner, and Mr. Townsen did, the court did adjourn, so we could review it. Since that day, Mr. Townsen has kept no contact with me. I spoke with Mr. Haven yesterday in his office, or I think Tuesday in his office. Mr. Townsen marked up the PSI, dropped it off to Mr. Haven. So that's just the record. I haven't had a chance to talk to him about what corrections he wants. He hasn't reached out to me. I've reached out to him numerous times. I've texted him. And Mr.
My
Townsen.
phone's broken right now.
Again, if his phone's broken, it's still his obligation.
I
to keep in
know,
touch with
I
me.
get that.
So for the record, I haven't reviewed that with him, but he has a copy of it. He's marked it up. I think he can always do it for himself. At that point.
Okay. Mr. Townsen, what do you think is inaccurate about the PSI?
There's a lot of inaccurate information. There's nothing that mentions my daughter in either one of the cases. That was the reason why I acted as such when they busted into my room over a child support warrant, civil infraction. It's not even a crime. And now I had copped a felony out of this because I was under the interpretation by my lawyer, like I said, that I wasn't able to beat either one of these cases because I can't keep my composure in front of them long enough or in front of a trial judge or jury long enough. And obviously I'm trying. It's frustrating. My daughter's birthday is in 2 days. I was trying to tell her yesterday, actually, try my best to see if I could be. And because of the holiday, it wasn't why I received that late. It was never mailed to me as such. You can see by the.
So it doesn't matter. I gave you a whole nother month.
That's okay, but I'm saying, but I was, the last time we were in here, he was willing to, and so was the prosecution to go along with prosecuting me illegally because I did not receive that in time to review it.
But you had time.
And now I did, but I'm saying the last time, that's why I was forced to delay it. But everybody was more than willing to go along with prosecuting me then.
I don't think that was
Other than
anybody's
myself.
fault. I think that was just.
It was never mailed. It was thrown in my mailbox the day that I was talking to my lawyer about it. It was never mailed to me.
Anyway,
It was never mailed. I have people that work in the post office that was never stamped and mailed to me. So he forgot to put it in my mailbox. That's incompetence. Or somebody forgot to send it and it wasn't there.
That doesn't matter. You had time. But anything other than the fact that your daughter is attached to there.
Yeah, the dog bite, them attacking me. It's a lot. I don't even have my PSR and I can't sit here and break it down.
Why did you break
That John Haven had, he just said that.
You gave it to him?
Just review it.
We'll get it back.
I don't want to grab it from her.
You don't want to go through it.
I don't want to grab it from her. To be honest.
I can get it.
First of all, I was told by both of them the sentencing guidelines would be different, but they didn't know that. They served is wrong. Whatever this deputy Haven believed that the defendant was avoiding contact, that's irrelevant. That's just his opinion, it doesn't matter. It didn't even need to be said in here. That wasn't even in the police report. Yeah, and then, said Debbie Taylor requested assistance, he came back with 3 other officers at 1 o'clock in the morning, shining the flashlight in my daughter's eyes. There's no mention of any of that going on. My daughter crying, me. If we go down to here, something about we are not doing that. That's not even what I said. I asked them about handcuffing me in front of my daughter. We were in the room with her. She was right behind me. I asked them, can we not do that in here? Can we go outside and do this so that she doesn't have to see me get handcuffed? She's already seen it enough. And no, they just spin me around, snatched me up, run me out of the room. She was crying. I said something. They started laughing. That's when I said the F y'all thing. So that is accurate. But that was under the circumstances. I mean, am I really supposed to go through this whole page with you right now?
That's up to you.
Well, you were trying to tell me that this doesn't matter right now. So
what I said was the fact that it didn't get mailed to you doesn't matter because you had another month.
No, now I've had another month, but I meant then, that was why I wanted to say what I said, because everybody was willing to prosecute me illegally at that point. Less than 24 hours when I was allowed at 48.
You started with what I said about it not mattering, and that's what I was referring to, not this. So this is up to you if you want to tell me things you think are wrong with it. This is your chance to do that.
I mean, the fact that this whole other case is being dismissed is even listed as such, I feel it should be in there. Or at least in that much detail, because then there's nothing even listed. It just makes me sound like a villain. Okay, for real. And if it's getting dismissed, why is that even in there? That shouldn't even be part of the prosecution on the other charge. Because if the other charge didn't happen, this one doesn't happen. Didn't provide what happened, because I'm going to sit here and tell you what happened myself. The attempted headbutt was not as described. They asked me to stand up. I went to stand up and he smacked me in the head with a riot shield to sit back down. And I wish that we could, play the video right now. But feel that they listed headbutt because that's what I've already been in front of you for, was actually headbutting an officer. So it feels like that if they throw it in there, it might be able to stick a little bit better. the day my dad died is wrong. Sometimes I figure that through in there. Although my classes, in the beginning, when I was in prison, my classes were delayed. It makes me seem like I was trying to do it. It was because of COVID. I had to stay longer. So I actually got punished in prison longer because of COVID. I had to stay and finish classes. It's been high since it's been higher. It's higher than it's ever been before. I was at the doctor's yesterday. My blood pressure is through the roof. Stomach issues, all kinds of anxiety. I just got my meds bumped up because of this. I don't agree with the recommendation whatsoever. I don't feel that I even did anything. So go back to stuff I was in this case, but part of this did something that I didn't do, and I'm getting punished harder than if I had done what he had done, if that makes any sense. I don't really want to talk about his case. Okay. I don't know if you understand what I'm trying to say.
I'm not sure. He didn't get punished as bad for the same thing that you did.
No, a worse offense.
Worse. Okay.
Or yeah, or actually something that was actual physical rather than just a verbal exchange, as in my case. Okay. And I'm getting punished more so. I'm not trying to put his business out there. He's in here with me. Like I said, the credit days, I think it's one more than what is on there. I mean, I could be wrong, but that sounds petty of me, but I want every day if I'm going to end up having to say. I guess back to this page, which is verbally assaulted. I was frustrated because of the situation. I wasn't verbally assaulted. I don't like that terminology either. I feel that, like I said, I feel like it makes me feel like it makes me look like more of a villain than I am.
Mr. Gerber, in terms of the scoring from a legal standpoint, did you have any objections to the scoring?
I did not have any objections to scoring. Reviewed that the last time Mr. Townsen was here. And I did again bring my sentencing guideline to go over it with him, but there are no challenges.
Ms. Hope, do the people have any changes, additions, solutions, corrections?
No,
Do you have any challenges to the scoring?
I do not.
Is there anything that you want to say regarding sentencing?
Mr. Townsen, as charged in either of these cases, would be looking at 2 to 34 months. I know he has a supportive family. I've actually spoke to his mother about him previously. He has the ability to be a nice person. He has a terrible temper. We can see it in the court today. He seems angry. He got a very good plea offer. I think the recommendation is appropriate. And I agree with Mr. Haven's recommendation that he's not a good candidate for probation. So I think a straight jail and being done would be appropriate. Thank you.
Mr. Townsen, did you want Mr. Gerber to make any kind of statement on your behalf here today?
Because I would just simply state, I think we looked at this plea offer, understanding there were some defenses, Mr. Townsen, there. He's right at the start of the child support warrant. I think, we even conferred with Deputy Taylor, who's here at the time of the prelim, to understand why and what happened. And I think given the bigger picture of everything else, this was worked out the way it was worked out. If he did go to trial, there'd be 2 separate trials, and I think he would have scored out to a prison recommendation. So I did sit down with Mr. Townsen and score him out if he went to trial, what his guidelines would look like and what the guidelines would look like under a plea. And certainly he understood those. So I think if he's asking that the guidelines be adjusted, I think that would have been, if he went to trial, what they would have looked like, and versus the plea, what they would have looked like. So I understand where Mr. Townsen is coming from with his child being in the home. Again, there were child support warrants that were initiated. He believed there were civil infractions, but they were not. There was still an arrest warrant for the lack of payment of child support.
No, the civil infraction was the failure to comply with the court order for the payment of child support. That's what they came for.
So he was there there was an arrest warrant that was there that initiated all of this. And I think this could have been all mitigated. I think the scope understood that as well when we resolved this matter. So for all those reasons, I would again just leave that in the discretion of the court with one of the appropriate sentences.
Mr. Townsend, is there anything else that you wanted to say?
The child support is resolved. Yeah, well, I'm in good standings with Wendy next door now because of all this, obviously, but, and then, like I said, it wasn't the child support that was, like I was mentioning, was a civil infraction. It was the failure to comply with the court order because I was supposed to pay so much by a certain date, and I didn't, and then ended up, that's what happened.
Judge, I should just add that the child support, he's correct, that was all resolved early on before these criminal matters were resolved. Both of those cases, he did enter into a payment plan with the front of the court, was making payments, so he's in good standing there. So I think, again, to the credit of Mr. Townson, what started this, he did take care of those issues. So I think the court should
I have a ton of receipts in my paperwork.
All right. So yeah, I mean, I think, it's clear that you have a problem with impulse control, and officers are just there doing their job. Might not like it, might not agree with it, but resisting is not the way to deal with it. And sooner or later, you have to figure out a way to deal with that, whether that's through medication, therapy, counseling. You need to get some help because you're just going to continue to wind up in the same spot because you're not able to control yourself. Very out of that. Probably everybody else that knows you. Yeah. Don't get help with it, you're just going to spend more and more time in jail. This was a good plea agreement for you. It resulted in much lower guidelines than a guilty verdict would have been at trial. The recommendation is even at the very low end of the guidelines. I think it's appropriate to account for your conduct in this case. And before this been 70 to 90 days in the Crawford County Jail, for 12 days served. The court is going to order a crime victim assessment in the amount of $130. Court costs the amount of $325. Attorney fees in the amount of $350. Cost of $68. You have the ability to what your power rates are, and how to request a lawyer to help you with the deal.
I was trying.
Yes. This is yours. Judge, just for the record, Mr. Townson does have his own paperwork.
Versus Bradford, case number 23520.
Sierra Cook on behalf of the people.
Can we give Mr. Bradford a mask, or would you like a mask?
I don't have a mask. I am sick.
We got one here.
Yeah, I am sick about, so.
Sure.
I give up on this report.
Okay, great, thank you. So the record should reflect Mr. Bradford's present here in the courtroom today. Yeah, I did say this is case 23502, Beck, Townsen.
Sierra Coke, on behalf of the people.
Thank you, Mr. Bradford.
Where are we at here with this case?
Judge, I was appointed to this matter on 118. I really haven't had much discussions with Ms. Cole on this matter. I'm still waiting on transcripts and prelim, and Representative Bradford previously had more than 5 terabytes of discovery. I know Ms. Cole's office indicated that if I brought up a 5 terabyte external hard drive, we could put it on. But I emailed her really quickly. It was just easier to get the discovery from her. She did send me an email, so she was out of the country. She was back this week. I would get it. She is, I'm waiting for that. And I just have to navigate the issues that this case presents. The scope is indicated to me with the plea offers. I've discussed that and again, defenses with Mr. Bradford. I think I need all of that to make more sense to Mr. Bradford, to understand what his options are at trial, what his options are at plea, where this stands. So I know there's no trial date set up because I don't have that notice. So I don't know if the court wants to give me just a 30, 45-day adjournment so I can work through that with Mr. Bradford.
All right, Ms. Cole.
Your Honor, I would ask to put this on the trial docket and set a final cutoff. I know Mr. Gurmurthy is new. 3 weeks ago, the day he was appointed, we sent a letter asking if he wanted an external hard drive with these videos. We don't have a method to put them on there because there's so many. Usually when we have that situation, we offer that they either come to our office and watch them or get them. They're short videos. There's just 6 of them from different directions. We have had 3 adjournments in this case at the defense's request, one on 9/8/23, one on 11/8/23, and one on 1/5/24. We are prepared for trial. The officer in this case was injured. He remains off work to this day. Does not know when he's going to be returning. We are prepared for trial. We can get that discovery to Mr. Gurmurthy. Alternatively, he can just, rather than order a transcript of the prelim, if he needs to prepare, he can get a copy from district court. It just takes a couple of minutes to put in a request and he can watch the prelim. So we're prepared for trial. Thank you.
So, Mr. Gurmurthy, I think, and I know you're recently on the case, but it's been found over since July. What I'd like to do is have this set for a trial at about 120 days out.
Okay.
With a plea in motion cut off at 90 days. So that'll give you a number of months to go through the materials, speak with Mr. Bradford. Mr. Bradford, you'll have a few months to decide whether you want to accept any plea agreements or whether you want to go forward with the trial. But that way we'll have it on the calendar and get your case taken care of.
I think that's very appropriate, Judge. That time frame would be fine. I would treat this as my first status conference. I think that's how the court's treating it. And for the record, I wasn't involved in those prior adjournments, so I don't know what the delay was, but I think I just need to get those discs at this point. The transcripts and we should be set.
This quick, how many days of trial?
1.
1 day. All right, Mr. Bradford, did you have any questions?
No, I'm doing my therapy. I'm doing what I can to help you guys out. It was never supposed to get this far in the first place. I just want my stepbrother to help clean. It was never supposed to get this far.
Well, just make sure you stay in touch with Mr. Gurmurthy so that you're ready to go.
I'm doing my best.
Okay.
And for the record, as soon as I was appointed, he kept in touch, so I anticipate that to continue.
Okay, thank you, that's all for today.
Thank you.
You're on behalf of the people.
Thank you. Jason Townsen on behalf of the defendant, James Mellon. I haven't had any contact with Mellon since the last 4 years, which I believe she failed to attend. So, yeah.
Your Honor, we had a hearing on 116. We have a jury trial set up. We have no additional information because it was set for a show cause and not a bench warrant. We could not send officers to look for her. We couldn't arrest her anyway. So I don't know what we're gonna do with the jury trial, but it doesn't sound like we're gonna be able to go forward. We'd ask for a bench warrant.
I'm gonna leave the trial date on for now, recognizing that, that's 5 days away. We probably wouldn't try it, but I don't wanna adjourn the trial in case the felon happens to appear on the 13th, but I'm not gonna expect counsel to be ready to go forward. The scope the court will, sign that bench warrant once that's presented. And we'll proceed further as soon as we can have Ms. Mellon arrested for the court again. If she does appear on the 13th. Or arrested.
Do I assume correctly the court will be calling off the jury then?
Yeah, we won't have a jury. Doesn't.
Just so we'll have a trial date, just no jury.
Correct.
Thank
So
you.
court expects counsel and Ms. Mellon to be here in person, but not a jury.
Right.
All right, I will be here, Your Honor.
Okay. Let's go any further on this file.
Your Honor.
Okay, thank you. That